Viewers, Namaskar and greetings. I present to you the judgments seen during second half of April 2026. That is from 15th of April to end of April, that is 30th of April. In the first half of April, there were many holidays. So as a result, the number of judgments were less. Whereas in the second half of April, there has been a flurry of judgments and vital ones as well. And it was really difficult to segregate 10 or 11 out of them because we cannot possibly bring to you about 20-25 judgments. Then the video would run for about 2 hours. So I sincerely hope you are going to like the judgments and do recommend, give your likes and comments. And with this, I take you over to the main video.
We are on the screen of Section 3, Subsection 27 in Guide to IBC website. Section 3, Subsection 27 deals with property. As we know, the term asset is not described in Insolvency Bankruptcy Code. Hence, property includes the term asset also. Our topic of interest is topic number 14, which says that the money deposited by a corporate debtor in a court as security pursuant to a court order prior to commencement of CIRP do not cease to be an asset of the corporate debtor merely because they are in the possession of the court. Let me read it out again. The money deposited by a corporate debtor in a court as a security pursuant to a court order prior to commencement of CIRP do not cease to be an asset of a corporate debtor merely because they are in the possession of court. Our interest is case of Morarji Textiles Limited and another versus Union of India and others, writ petition so-and-so of 2012, Bombay High Court. Now don't go by 2012, this is a very recent judgment. Now in this, what happened is, Morarji Textiles Limited issued a work order to respondent. Respondent was an MSME unit. There was dispute between the parties, and since the respondent number 3 was an MSME unit, it approached the MSME authorities, who directed the petitioner, that is Morarji Textiles Limited, to pay deposit a sum of 13 crore 44 lakhs 32,888. The petitioner went to approach the Bombay High Court, and Bombay High Court on 5/7/2012 directed the respondent to pay 75% of 13 crore 40 lakh as deposit, just as a deposit. Morarji Textile Limited approached Supreme Court, and Supreme Court reduced the amount of deposit from 75% to 60%, and said that this amount could be deposited by way of either a bank draft or by way of a bank guarantee issued by a nationalized bank. In the meanwhile, Axis Bank moved to, in 2012, 2014, 2024, moved to NCLAT and moved a petition under Section 7 of Insolvency Bankruptcy Code for commencement of CIRP, which was admitted by NCLAT Mumbai. An IRP was appointed, who became an RP in due course. The RP approached the court to refund the amount. It may be worthwhile to mention here that even the respondent also has responded while it deposited a claim, it submitted a claim with the RP. Nevertheless, it also approached High Court to refund the amount. So Bombay High Court came up with a beautiful judgment, which I would strongly recommend my viewers to go through this. This is absolutely a nice judgment. So to make things short, precise, and understandable, because we don't have time to go through the entire judgment. So let us, I have prepared a slide for you, and let me take you over to the slide. Bombay High Court said on 9/2/2024, NCLT admitted application filed under Section 7 and declared moratorium under Section 14 of IBC. While the order dated 11/2/2026, Bombay High Court permitted RP to make necessary amendment to the petition and prosecute the petition also. RP and Respondent 3 have filed applications respectively. Both are seeking permission to withdraw the amount deposited in this court. According to the RP, the amounts were deposited from and is subject to ongoing CIRP under IBC. I've already mentioned to you that RP has filed a petition and remaining of the cases, remaining matters which have been discussed in the highlights up till now. In the instant case, this court, while granting interim relief, had directed petitioner number 1, which is now the corporate debtor, to deposit 75% of the amount covered by the award of 13 crore 40 lakhs odd. Here, the moratorium proceedings have commenced. RP has been appointed, and respondent number 3 has submitted its claim, and in that sense, has submitted itself to the jurisdiction of moratorium proceedings. That means respondent 3, which is an MSME unit, has submitted its claim and comes within the jurisdiction of moratorium proceedings, which prohibit continuation of any case. Recovering money while the CIRP is going on. So those are no more permitted. So by submission of claim, it has come within the jurisdiction of moratorium clause. Section 310 of IBC defines a creditor to mean any person to whom a debt is owed and includes a financial creditor, an operational creditor, a secured creditor, unsecured creditor, and a decree holder. So the MSME unit or respondent number 3 is a creditor of the corporate debtor. There is no doubt about it. The direction issued by Supreme Court to encash bank guarantee is to comply with the order by this court, directing the petitioners to deposit the amount as a pre-deposit to entertain the petition. The amount so deposited would belong to a corporate debtor petitioner company, and therefore it is his asset. Why? The money deposited by a corporate debtor in a court as a security pursuant to a court order prior to commencement of CIRP do not cease to be an asset of the corporate debtor merely because it is in the possession of the court. The money was deposited by the corporate debtor, and the dispute has not been settled till now. So that it continues to be the asset of the corporate debtor. There is no doubt about it. Honorable Bombay High Court disposed this petition with a direction to registry of this court to release the amount deposited in this court, along with the interest accrued thereon, in favor of the RP for payment to creditors in accordance with the provisions of IBC. So this is a beautiful judgment, and it is just not covering Morarji Textile. It can be applied to so many other cases. And it is an exception of an exceptional case. And I would strongly recommend my viewers to please go through the judgment, because it will impart a good understanding of the subject, what a property is, and what is the ambit of Section 14 moratorium also. With this, we move on to the next slide. We are in Guide to IBC, we are in the screen or dashboard of Section 5, subsection 8, which deals with financial debt. Our focus is topic number 79, which says that a liability arising from corporate guarantee squarely falls within the ambit of financial debt as defined under Section 5(8) of the Code. The case is a very recent case of Honorable Supreme Court, that is State Bank of India and others versus Doha Bank QPSC and other civil appeals were so of 2022. This happened very recently. In this case, what happened was Reliance Communications and Reliance Group availed a foreign currency loan of $250 million from Doha Bank in 2011, 2010-11. Before availing that, it had already availed loan from consortium of banks led by State Bank of India. And on 2017, corporate guarantee was also executed. Now, the company was declared as NPA, and obviously, insolvency proceedings started. And it was admitted to insolvency. On when corporate guarantee executed in favor of State Bank of India and other consortium that were placed, Doha Bank disputed existence of such guarantee on the security trustee, and they said that this is not acceptable. The RP also was in dilemma. The matter went to NCLAT, and NCLAT on 13/4/2019 allowed withdrawal of the appeal and asked NCLT to proceed with the case. But in both cases, both later as we'll find, both NCLT and NCLAT did not accept the corporate guarantee of SBI, the consortium of banks. The matter went to Supreme Court. Now, this is an extensive judgment, and I would strongly recommend my viewers to go through it. But in order to make things precise, let me take you over to the slide which I prepared for you. The Honorable Supreme Court observed the following. A liability arising from corporate guarantee squarely falls within the ambit of financial debt as defined in 5(8) of the Code. It is well settled legal proposition that a guarantor incurs coextensive liability with that of the principal borrower, and such liability is enforceable in law. In the present case, the execution of corporate guarantee executed by CD in favor of security trustee for or on behalf of appellant has not been disputed by CD. So CD has accepted the execution of the guarantee. The account of CD was first declared NPA on 22/8/2016. However, the same was subsequently restructured by the consortium of banks. In lieu of thereof, the CD executed corporate guarantee in 3/3/2017. However, despite restructuring, the account again became NPA on 20/12/2017. The RBI Master Circular mandates that in case of restructured assets, its assets classification will be recalled from the date it became NPA on the first occasion. So it had first become NPA when on 22/8/2016. Mere non-disclosure of corporate guarantee in the financial statement of CD for financial years 2016 or 2016-17 or 2017-18 cannot deprive the appellants from making claim on the basis of these guarantees. The appellant had produced letter dated 6/3/2019 before NCLT, issued by security trustee, wherein the said trustee confirmed that he executed and stamped version of the corporate guarantee is in their custody in New Delhi. The RP inspected the aforesaid guarantees, verified the same by visiting the office of the security trustee in New Delhi. So the existence of guarantee was well established. The corporate guarantees was produced before the NCLT. Therefore, merely because they were not produced before NCLT, no adverse inference can be drawn with regard to genuineness of the corporate guarantees. It was not presented before NCLT, but before NCLT it was produced. So there was no question of these not being genuine corporate guarantees. Non-stamping or improper stamping does not result in instrument becoming invalid. The Stamp Act does not render such instrument void. The non-payment of stamp duty is accurately characterized as a curable defect. Merely because the corporate guarantee were not filed along with Form C, the claim of the appellant could not have been negated. The tribunals at the insistence of the lender grossly erred in rejecting the claim raised by the consortium of lenders. So this is a vital judgment. Once a corporate guarantee is there and the claim is lodged, it has to be accepted because the liability of the guarantor is coextensive with that of the principal borrower. And this is a Supreme Court judgment, a very new judgment. So I would strongly recommend my viewers to go through it. With this, we move on to the next slide. We are still in the dashboard of Section 5, subsection 8, which deals with financial debt. And our attention is topic number 78, which is also a very recent judgment. Before coming to the judgment, let me read out the topic for you. Topic number 78 says, where no disbursement was made by the home buyer in favor of the corporate debtor, it cannot be classified as a financial debt under Section 5A. The case of L&L Partners litigation versus Jalesh Kumar Grover, RP, Company Appeal so-and-so of 2025. Now, in this particular case, L&L Partners litigation, you can well understand that it is a law firm. And in lieu of their services, the company had allotted, the developer had allotted certain apartments to them, and which were not approved in the resolution plan or so, and they lodged a complaint. That's why that thing should not be taken into account. Well, in the course of the judgment, NCLAT referred to the judgments of Messrs. Property Real Estate Solutions Private Limited versus A. Vishwananda Sharma, RP, Sunibera Development Private Limited, in which it was held that if there is no disbursement, then it cannot be held as a financial debt. Even they referred to the judgment of Anuj Jain interim IRP of JP Infratech Limited versus Axis Bank of Supreme Court, wherein also it was held that for a financial debt to be there has to be disbursement for consideration of time value of money. So this case went on and the judgment. So in order to understand it better, let me take you over to the slide. Now, NCLAT, let us understand snapshots of the NCLAT judgment. The claim was filed by appellant by letter dated 8/1/25, claiming allotment of Acme Projects Limited for 3 units G601, G701, and G801 in Acme Rega, for total consideration of 2,44,08,565. The allotment was made towards adjustment of bills of the appellant firm towards legal fees, as I told you. The claim was not admitted both on the ground of filing delay as well as on merits. The reason given by the adjudicating authority refusing to condone the delay in filing of the claim by appellant, a legal firm, cannot be said to be arbitrary and without basis. The reply of the RP mentioned the name of the appellant is not included in the list of 221 allottees, which are part of the order of district magistrate dated 10/11/25. Actually, Section 13(4) had already been invoked, and there was a question of taking over the asset and auction, and a report of district magistrate was sought, in which district magistrate gave details of 221 allottees, in which the name of the L&N Partners litigation was not there. The sale certificate, which was issued pursuant to auction sale in favor of the corporate debtor under SARFAESI Act 2002, is part of record in which the sale certificate clearly refers to 220 buyers. It is thus undisputed fact that encumbrances of 220 home buyers was noticed in the sale certificate. Admittedly, the same of the appellant was not in figure in the list of 220 home buyers. When there is a list of allottees totaling 220, which is part of the sale certificate, in which the list of the appellant is not there, the submission that there was any liability on the corporate debtor towards appellant cannot be accepted. Amount raised from allottees under real estate project has been deemed to be an amount having commercial effect of borrowing. Where disbursement was made by a home buyer in favor of corporate debtor, it cannot be classified. When no disbursement was made by the home buyer in favor of the corporate debtor, it cannot be classified as a financial debt under 5.8. So that means what? In the event we are looking into, this is a very important step, because home buyer is a hot thing and so many home buyer cases are taking place. So if somebody is receiving an apartment by way of, in lieu of an operational debt, that is for rendering services as architect or lawyer or things like that, in such case, it classifies as an operational debt because there is no disbursement of funds for consideration of time value of money. So in such case, it need not be, the allotment need not be considered. They don't classify as a home buyer. I mean, they classify not, they may be home buyer, but not coming under 5.8. So the umbrella of 5.8 does not apply to them, at least as of now, as held by NCLAT. And since they have referred also to Anuj Chair, so there is a Supreme Court angle. So as of now, this is the law. And this is very important. So with this, we move on to next slide. We are now in the dashboard of Section 7 of Insolvency Bankruptcy Code, as you see on Guide to IBC website. Section 7 deals with initiation of corporate insolvency resolution process by a financial creditor. Our topic of interest is topic number 153. Topic number 153 says that it does not mean that every decree holder who also happens to be a financial creditor is entitled as a matter of right to invoke insolvency process in preference to execution. The case is of Anjani Technoplast Limited versus Saurav Gautam, civil appeal number so-and-so of 22. This is also a very recent judgment of Honorable Supreme Court. And this is really an interesting read. It so happened that the appellant filed the case, that is Anjani Technoplast. And Saurav Gautam, that is the respondent, is a money lender. So sometime in 2010, he had given an advance of 2.5 crore to the appellant, that is the corporate debtor. The corporate debtor failed, and then subsequently also he made another advance in the following year. The check given in for repayment of the amount bounced. So there was a 138 proceeding as well. And there was an understanding, also MOU between both the parties, in which the corporate debtor agreed to pay certain amounts. as a certain amount as full and final settlement, which actually did not happen. The respondent filed a suit in Delhi High Court, and Delhi High Court in 2018 gave it a decree of 4 crore 38,617. And the parties again decided to settle the matter, but they didn't get settled. Rather than proceeding for execution of the decree, the respondent went in for Section 7, invoked Section 7 in Companies Act, because he was the decree holder, and stating the decree holder is a financial creditor. The matter went to NCLT, and NCLT dismissed the petition on 20th June 2022, stating that a decree holder is a separate class of creditor under Section 310 of IBC and does not automatically become a financial creditor. So, and it does not come under Attract 5.8 of the code. So the matter went to NCLAT. NCLAT referred to the Dena Bank judgment and said that reversed the judgment of NCLAT and said that corporate insolvency could very well be invoked because a guarantee does form a financial debt. And also, NCLAT also referred to the judgment of Kotak Mahindra Bank versus A. Balakrishnan 2022, SSC 186, which held the correctness of Diraback ratio. So the matter, so automatically, since the situation was different, the appellant went to refer to Supreme Court, and Supreme Court dealt with the matter. And it's like money, interest now. This guy was charging, the lender was charging 3% per annum. So he was in between, he went to High Court, filed another petition that so much money was due to him. So it was increasing day by day, day by day. And even the appellant, he went to the court and said that no, this calculation was wrong. These things were going back and forth. So this is a very interesting read. And I would strongly recommend my viewers to go through this judgment. But in order to make things simple and understandable, let me take you over to the slide which I prepared for you. Now let us see what Supreme Court said. The IBC purpose is the rescue and revival of corporate debtor as a going concern. The resolution process is not intended to be adversarial towards the corporate debtor, but rather to be protective of its interests. Improper use of IBC mechanism by a creditor, includes using insolvency as a substitute of debt enforcement or attempting to obtain preferential payments by coercing the debtor using insolvency proceedings. This is a very, very important observation by Supreme Court. Improper use of IBC mechanism by a creditor includes using insolvency as a substitute for debt enforcement or attempting to obtain preferential payments by coercing the debtor using insolvency proceedings. The initiation and maintenance of CIRP proceeding against the appellant cannot be sustained. Why? The respondent holds a decree of Delhi High Court dated 11/1/2018 for 4 crore 38 lakh 617 with interest at 24% per annum. The decree was affirmed in appeal, and this court dismissed the SLP, that is Special Leave Petition, on 22/10/2021. The decree has attained finality. The decree is a money decree, and the machinery for its execution is well established and effective. The respondent chose not to avail of that remedy. A decree, it's a money decree, and there is a full-fledged mechanism to execute the money decree. So, but the respondent here did not avail that, and instead it went to insolvency. Instead, he filed a petition under Section 7 of IBC on 13/12/2001, barely 2 months after the SLP was dismissed. The appellant was a running company with revenue approximately 35 crores, profit 8 crores, 95 full-time employees. The appellant deposited 3 crores with the Registrar General, and a further sum of 60,98,847 was deposited in compliance with this court's order 18/10/2024. So the appellant deposited 3 crores. Earlier it had paid also, and now it had deposited 3 crores and 60,98,470. These are not the habits of insolvency of an insolvent entity. Court observed that these are not habits of an insolvent entity. These are instincts of an earnest judgment debtor, willing and able to satisfy its liability, but disputing the quantum claimed. The insolvency jurisdiction of IBC is not designed to resolve dispute amongst the quantum of decretal amount. It does not mean that every decree holder who holds to be a financial creditor is entitled as a matter of right to invoke insolvency proceeding in preference to execution. NCLAT erred in setting aside NCLT's order dated 26/22 and directing the admission of Section 7 application. So what we find here? This is an exceptional judgment. Exceptional judgment. Because here, decree is, as per Dena Bank judgment, is a financial debt. But here it has been denied. Because why? The company was a running concern, having 95 employees, making 35 crore revenue, earning 8 crore profit. It had deposited money and quantum towards interest also, but it was disputing the amount which was claimed. And the fact that the decree holder had a full-fledged mechanism as provided in the statute to recover its dues. But instead of opting for that, it went for insolvency proceeding. So insolvency proceeding here was what? Arm twisting the borrower, pay the money in preference. So which was detected by Honorable Supreme Court. And this wonderful judgment came out. So with this, we move on to the next slide. We are on the screen of Regulation 35, which deals with valuation. I often tell my viewers not to evaluate a judgment based on the number of pages it comprises. So, what is most important is what it consists, whether it is an exception by itself. And this particular case, which I'm going to discuss right now, comprises of only 2 pages, rather 1.5 pages. But it shows a new thing, and which we need to keep it in mind. So let us come to topic number 18, in which it says that the adjudicating authority in exceptional circumstances may direct appointment of a third valuer. Now, what we know, the valuer can be appointed by the RP. And if there is a difference in valuation of the valuers of more than 25%, then it forms a significant variation. And then RP can appoint a third valuer. And COC at its discretion can appoint a third valuer at any point of time. So the very fact that adjudicating authority can appoint a valuer is nowhere mentioned. Now, this particular case is an exception, and it says that the adjudicating authority in exceptional circumstances may direct appointment of a third valuer. This is something absolutely new. Now, let us go to the case. The case is of Mr. Sanjay Kumar Gupta, RP, versus Platinum Blue Estate LLP, company appeal at so-and-so of 2026. Now, in this, the background is the adjudicating authority passed an order directing for appointment of an independent valuer. In para 5 and 6 of the order, it says that the resolution plan is especially highly undervalued and the true and correct picture has not been brought on record. It appears that the respondent and Cliff Cornwell LLP are attempting to play fraud on this honorable tribunal. After hearing the parties, we are of the considered view that third valuer ought to be appointed from the panel of IBPI. In the circumstances, we deem it appropriate to appoint so and so, email so and so in the present case. The appeal was filed by resolution applicant, and the learned counsel of the resolution applicant submitted that respondent 1 had no locus to the application for directing for valuation. It was submitted that the respondent 1 themselves have appointed some architect to value the assets, which has no meaning or relevance. But despite that, adjudicating authority went one step ahead. Said that the resolution plan is not properly valued. It seems to be assets seem to be tremendously undervalued. And the Cliff Cornwell LLP is attempting to play fraud with the honorable tribunal. So it directed for appointment of another valuer. Now the matter went to NCLAT. We'll come to what NCLAT has said in this slide, which I'm going to show to you. NCLAT, Honorable Appellate Tribunals, opined that adjudicating authority had observed the respondent and Cliff Cornwell LLP are attempting to play fraud on the tribunal. When observation has been made by that the parties are trying to play fraud, the court has every jurisdiction to issue any direction. There is no reason to interfere with the order by which valuer has been appointed by adjudicating authority. So that is the final status. So and what is most important is, this is not against value, at the time of progress report. It is apparent that a resolution plan was submitted. And then the court observed that the assets of the company was highly undervalued. And it felt that some foul play was going on. And that is why this case is exceptional, despite it containing 1.5 page only. So I would strongly recommend my viewers to please keep this case in mind. It's a gem of a case, gem of a verdict. So with this, we move on to next slide. Viewers, we are on the screen, or rather of the section 29A. Let us first understand, because 29A is a long section and it has so many subsections. So in Guide to IBC website, you have 29A, which begins with the phrase, a person shall not be eligible to submit resolution plan if such person or any other person acting jointly or in concert with such person, dash. Our concern is subsection F. Is prohibited by Securities and Exchange Board of India from trading in securities or accessing the securities markets. So we know what section 29A F is. And our topic of interest is concerning that, and it is topic number 32, which says that the legislative scheme for prohibition under section 29A-F is not to examine the decision taken by SEBI, that is Security Exchange Board of India, prohibiting from trade in securities or accessing securities markets. That is not the jurisdiction vested with adjudicating authority. Clear? Or let me read it out again. The legislative scheme for prohibition under Section 29AF is not to examine the decision taken by SEBI prohibiting from trade in securities or accessing securities market. That is not the jurisdiction vested with the adjudicating authority. SEBI's order stands, and adjudicating authority is not to look into why he has been barred. The fact that he is barred, and that is a prohibition under Section 29A. The cases of Carnet alias Fernandez versus Jagdish Kumar Barulkar and another, Company Appeal so of 2026. It is a recent NCLAT judgment. In this case, what happened was a Form G was published, but the suspended director of the CD did not submit any EOI. Later on, he expressed interest in submitting EOI. The Committee of Creditors considered the same and directed the RP to file a petition at NCLT. NCLT rejected the same. However, as per liberty taken by RP, while withdrawing the application, the RP proceeded to examine eligibility of the applicant and an eligibility report was obtained by RP. After considering the eligibility report obtained, sent a communication to the appellant on 11/6/2025, informing the appellant that the appellant is ineligible under Section 29AE and 29AF. And what happened was automatically the suspended director submitted a petition at NCLT challenging the verdict of the insolvency professional. And then NCLT went on with the case and the matter went to NCLAT. NCLAT looked into the matter in depth and came out with a verdict, which is going to be presented to you in the form of my slide share, the slide which I have prepared for you. So with this, let me take you over to the slide. Now, what did NCLAT say? The appellant suspended director of the CD has not submitted EOI in pursuance of Form G issued on 21/3/25, which I told you. The appellant, having never given an EOI, his name was not included in the final list of PRAs. COC directed RP to obtain permission from NCLT for accepting resolution plan from the appellant. The RP filed an application on IAS so which came to be dismissed as withdrawn on 6/6/25. As per liberty taken by RP while withdrawing the application, the RP proceeded to examine the eligibility of the appellant and an eligibility report was obtained by RP. The RP sent a communication to the appellant on 11/6/25 informing the appellant that he is ineligible under Section 29AE and 29AF. The appellant, apart from being a suspended director of the CD, was also promoter of GEI Industrial Systems Limited. Paragraph 4.2 of the order clearly prohibited appellant from directly or indirectly access the securities market. This paragraph 4.2 is an order of SEBI, which directed the promoter of the CD, the director of the CD, who was also promoter of a company called GEI Industrial Systems Limited, to directly or indirectly access securities market. 29AF makes a person ineligible to submit a resolution plan if such person is prohibited by Securities and Exchange Board of India from trading in securities or accessing securities markets. The order dated 26/6/2018 has been brought on record by appellant itself, which clearly prohibits the appellant from accessing securities market. The order of SEBI, which is in existence, has never been set aside, which is still in operation. The order was not set aside by SEBI. The legislative scheme for prohibition under Section 29AF is not to examine the decision taken by SEBI prohibiting from trade and securities or accessing securities market. That is not the jurisdiction vested with the adjudicating authority. The adjudicating authority has rightly held that the appellant is not eligible to submit resolution plan. The matter is very simple. If you are prohibited from accessing the securities market, SEBI has directed you to do so, not to access, denied you access, or denied you to participate in securities market, you are not eligible. Matter ends. Adjudicating authority is not to look beyond that. And that is the full stop where it should stop. And this makes this judgment is exceptional from that point of view because 29AF has been explained in detail. And I would like my viewers to keep this in mind. With this, let us move on to the next slide. Viewers, on your screen is the dashboard of Regulation 13 of CIRP process, CIRP Regulations 2016 on Guide to IBC website. Regulation 13 and topic in Regulation 13 is verification of claim. And topic number 24 says that Regulation 13 vests the power of verification of claims only with the resolution professional. The SRA cannot claim the power that has been solely vested in the RP. So SRA can never become a resolution professional. This case has got another, also applies to Section 31. And this is a home buyer case. So let us look at the observation in what is the topic in Section 31 also. So in Section 31, our topic is topic number 104, which says that an insolvency resolution process is not a casino where SRA can wager on the rights of stranded home buyers. This is a tremendously, I would say, strong remark by NCLAT. An insolvency resolution process is not a casino where SRA can wager on the rights of stranded home buyers. There are two cases. In fact, Sanjeev Sanghal versus Apex Heights Private Limited, company appeal so and so, and Jai Kishore Prasad and another versus Apex Heights Private Limited, company appeal so and so. Both cases are similar, absolutely similar. The Sanjeev Sanghal case spans about 100, about 79 pages. This is little less, but in this Jai Kishore case, there was a Regulation 13 also involved. So I'm presenting to you the Regulation 13 version because this will give you a new approach to the subject. So let us move on to the case. Now, in this appeal was moved by home buyers. This was a case of home buyers, and they had booked apartments. It so happened that because of in a sister concern of the corporate debtor, that is sister concern, that is Mascot Soho Homes Private Limited, but because of internal disputes within the home buyer group, within the corporate debtor group, their amount was transferred to the corporate debtor. And the allotment letters and bar builder bar appellants have transferred 3 lakh each to by bank transfers to the corporate debtor. The corporate debtor plunged into CIRP on 18/7/2018. This was at the behest of operational creditor, Pindal Merchandise something, and appellants filed their Form C on 7/8, actually it should be Form C8, on 7/8/2018, they claimed the amount already paid as and plus interest thereon. The question came that the adjudicating authority here directed the SRA to inspect the claims, to check and verify the claims. So the matter to which the exception was taken by home buyers, that how can SRA check and to what extent, and to what extent whether he can dismiss the claims or not. These are very pertinent questions. So for this purpose, the matter went to NCLAT, and NCLAT held a detailed judgment in this regard, which is an excellent read, both Sanjeev Sangal case and this case, and strong judgment in that respect. So with this, I would recommend my viewers to go through both the judgments. But let me take you to the slide which I prepared for you to understand the matter in a precise way. NCLAT, Honorable NCLAT, held that appellants have produced receipt dated 12/8/2015 issued by Mr. P.P. Singh as an authorized representative of the corporate debtor, MRPL, as an evidence. The corporate debtor has plunged into CIRP by order dated 18/7/2018, which I told you. This was at the behest of operational creditor Bindal Merchandise. The appellants filed their claim in Form C on 7/8/2018. They claimed the amounts already paid plus interest. Appellants' claim were partially admitted to the extent of the principal amount by RP by email dated 4/12/2018. It goes fine up to here. The application before adjudicating authority was filed for implementation of the resolution plan. The resolution plan was passed by COC. And application for implementation of the resolution plan was filed by RP, which was earlier approved by adjudicating authority by its order dated 20/2/2020. Under resolution plan, the SRA has undertaken to complete the project within 36 months in phased manner. Excellent. A holistic reading of clause 6 would show that the extent of SRA's power under resolution plan was to merely verify the original documents and enter into fresh builder buyer agreement. So SRA was to check and verify the original documents and enter into a fresh builder buyer agreement. Insofar as rejection of claims are concerned, the jurisdiction of SRA extended to finding the original documents Insofar as rejection of claims are concerned, the jurisdiction of SRA extended to finding that the original documents did not exist. The monitoring committee had already verified the claim of the appellants on 2/2/2022. Regulation 13 vests the power of verification of claims only with the resolution professional. The SRA cannot claim a power that has been solely vested in RP. So he has no locus standi to reject a claim. Once a claim of appellant has already been verified, the adjudicating authority could not have referred the matter to the SRA afresh for scrutiny. So, adjudicating authority could not have asked the SRA to scrutinize each and every plan, each and every document. Thus, SRA is stopped from claiming better information in dealing with corporate data than any of them. The adjudicating authority has erred in not admitting the appeal. So, what we understand is that two things. One is the power of SRA is limited to checking the documents at best, but not to disallow any claim, because the claim of home buyer is already admitted. He cannot do anything. And he has no right to disallow any claim, because it has been very clearly held by Honorable NCLT that insolvency resolution process is not a casino where SRA can wager on the rights of stranded home buyers. This is a very, very strong, these are very strong words. And this must be kept in mind. So SRA has got no right to reject claim of any home buyer for that matter, whose claim has been verified and admitted. So with this, we move on to the next slide.
Viewers, we are in the midway of our presentation. I do hope you like the judgments which we presented before you. More are going to follow, and I hope you will find them as interesting as our other judgments were. So with this, I take you over to the presentation.
We are on the dashboard of Regulation 18 of CIRP Regulations 2016 on Guide to IBC website. The topic number 3 says that it is clearly prohibited in Regulation 18(2) on the COC, even if it holds meeting after approving the resolution plan, from taking any decision which do not affect the resolution plan submitted before adjudicating authority. Meaning that even if COC would hold a meeting after approval of resolution plan, it cannot take a decision which will be detrimental to the resolution plan which has been approved. Clear? Now, the particular case which we are coming to has got reference to 18.3, 18.2, and also section 31 also. So let us go to section 31, and it is topic number 104, which says that once COC completes the exercise of approval of resolution plan, the role of COC comes to an end. So once it is approved, the role of COC virtually comes to an end. The cases of SM Kamal Pasha and another versus S. Rajendran RP, Company Appeal so-and-so of NCLAT of 2026. So let us go to Regulation 13 because this is the same what we have mentioned here. Now, this is an interesting case. Of course, whatever cases, there are so many cases happening every day. So what cases I bring to you are all interesting cases. But this is, definitely an interesting read. In this particular matter, what happened was a resolution plan was approved. Then one of the suspended directors, one of the members of the suspended board of directors, moved an appeal. The appeal went to Supreme Court. And later on, Supreme Court issued a stay order. And then dismissed the appeal. Dismissed the appeal on 9/12/2024. Honorable Supreme Court dismissed the appeal number so-and-so by its order and noted developments, including approval of the resolution plan in favor of the appellant and LOI dated 10/5/2021. So in between 3 years had already gone. And the matter kept on hanging and hanging. Later on, COC came to the point of view that why not we do one thing? 4 years have gone. For various reasons, 4 years have passed. So why not instead of the plan, we go for withdrawal of the thing? So the original SRA, the successful resolution applicant, moved the appeal before NCLAT. And NCLAT studied the entire background of the matter. And there are many cases which have been referred to in this. And this is a excellent judgment, I would say, because this deals with various cases, various instances. So one must go through this, excerpts of the judgment, which is featuring in the website. Let me take you over to the slide which I prepared for you. Now, Honorable NCLAT held that resolution plan submitted by appellant in CIRP of the corporate debtor was unanimously approved by CUC on 7/5/2021. The LOI was issued in favor of the appellant who submitted performance bank guarantee of 8,62,75,000 and IA and the IA number so and so was filed by RP on 29/6/2021 for approval of the resolution plan. The Honorable Supreme Court, by its order dated 9/12/2024, has noted the developments, including the approval of resolution plan in favor of the appellant. LOI dated 10/5/2021 issued in favor of the appellant also. The Honorable Supreme Court further has directed the banks and financial institutions who are the members of the COC to refund the money received from the corporate debtor, which was then to be converted into interest-bearing fixed deposits. Right. RP orally admitted that RP has been mandated by COC to seek withdrawal of IA, which facts have been noted in paragraph 2 of the impugned order. Submission of the COC representing 74% of the voting share was also noticed that Canara Bank has authorized RP to withdraw the IA. The adjudicating authority held that the resolution plan once filed, which may have lost its utility, obliterated with a flux of time, would still have effect of binding contract. Honorable Supreme Court has categorically held that resolution plan approved by COC is binding interstate COC and resolution applicant, which was done in EBIC software, EBIC Singapore judgment. The resolution plan approved by COC on 7/5/21 was clearly binding on the COC, and the COC had no jurisdiction to authorize RP to withdraw the plan. As per Regulation 18, the CIRP regulations, as per Regulation 18 of CIRP Regulations 2016, COC cannot take any decision which would affect resolution plan already approved by COC. It is clearly prohibited under Section 18(2) that the COC, even if it holds meeting after approving the resolution plan, from taking any decision which would affect the fate of resolution plan submitted to an adjudicating authority. The adjudicating authority in its impugned order has observed in para 5 that it is the fact that the present IA is pending before this court for over last 4 years for various reasons. NCLAT was not inclined to deliberate upon. The adjudicating authority committed error in permitting withdrawal of resolution plan on oral request by RP as authorized by COC. The COC has no jurisdiction to take any decision to withdraw a resolution plan. This reflects two things. I don't know whether a penal action will be taken against me. That our judicial system, in the insolvency process, there's tremendous amount of delay. Think of this particular case. It has been hanging for last 4 years. And why they wanted to withdraw the plan was because the company was running as a going concern and was making money. Or whatever be the reason. This cannot be allowed. And the resolution process should be, the approval of plan should be quicker. If it had been done quicker, much quicker, 4 years had not elapsed, I suppose this sort of situation would not have happened. But however, having happened, one thing is good that now we know that Regulation 18 prohibits COC from holding any decision, any meeting, or any decision which would affect the fate of resolution plan. And they had committed a mistake by asking the RP to withdraw the plan. And adjudicating authority also had made a mistake by allowing the request of the RP. So, this is an interesting case. With this, we move on to the next slide. We are still on the dashboard of Section 31 of Insolvency Bankruptcy Code. And our topic is topic number 123, which says that if adjudicating authority is not satisfied with the process culminating into resolution plan, and sufficient reasons are not given for rejection of plan, the liquidation cannot be avoided. The cases of Mr. Nirmal Gautam Shah RP versus Raj Radhe Finance Limited and others, Company Appeal so 2025. This is a detailed judgment, because you see, herein NCLT rejected a ban, which was unanimously approved by the Committee of Creditors. So NCLAT, while checking it, had to consider various things like A, that the underlying purpose for the plan is to resolve the insolvency forced by the CD, but to acquire immovable property for a price below the fair market and to gain unmerited advantage of the clean slate under Section 32A of the Code, and obtaining concessions since no genuine creditors had come forward to take CD in CIRP. Let me read it out again. A resolution plan has been rejected by adjudicating authority with no stakeholder opposing it. The adjudicating authority has entered into two significant findings. A, that the underlying purpose of the plan is not to resolve the insolvency forced by the CD, but to acquire the immovable property of the CD for a price below the fair market and to gain unmerited advantage of the clean slate theory under Section 32A of the Code, and for obtaining other concessions since no genuine creditor had come forward, take CD in CIRP. And the very admission of the CIRP was faulty. So, and this was strong view taken by NCLT. And NCLT obviously had to make in-depth analysis of the case. If you go through the judgment, you see it is segregated into chapters like setting the legal plane. Then comes impugned order tested, and thereafter we come to the conclusion part. So this is a long judgment. It will take us very long to go through this, but I'll take you over to the slide which I prepared for you. I'll strongly recommend, this is an exceptional case, and to go through the excerpts of the case as featuring on the website. So let us go to the slide which I prepared for you. A resolution plan has been rejected by adjudicating authority with no stakeholder opposing. Eventually, adjudicating authority ordered liquidation of CD. An adjudicating authority is not a mere counter-signatory to the COC and to lend its approval to a resolution plan, but a sentinel on the qui vive to uphold the spirit and objective of IBC. In adjudicating authority, just not a stamping authority. COC said, yes, it is a fact that commercial wisdom of COC is not justiciable. But that doesn't mean at the end of the day, adjudicating authority's approval is required. And it's just not a stamping authority. He has to look into it, whether the commercial wisdom has been rightly exercised or not. Income tax department had filed claim for 251 crores before the RP. The demand pertained to assessment year 2021-22. The resolution plan is submitted by two entities, namely Messrs. Deepir Enterprises and Messrs. Kanha Ventures. These entities together have 5 partners and their combined net worth of 16 crores, 93 lakhs, as per resolution plan filed on 19/6/2024. The same is shown as increased to 18.77 crores as per application filed by RP on 6/5/2025. The fluctuation in net worth of SRA was felt to be inexplainable. The plan contemplates the CIRP cost to be paid by corporate debtors' own available cash and fixed deposits, including fixed deposits of about 70 lakh created in September 2023. So, SRA was not paying CIRP cost. The plan said that the CIRP cost will be paid from the funds of the corporate debtor. The commercial decision of COC taken based on inadequate and imperfect information and in apparent disregard of the mandate of Regulation 38(3) of the CIRP regulations is liable to be scrutinized and not mechanically endorsed. The principal concern of the adjudicating authority is the systematic reduction in the value of tangible assets of the CD for 3 consecutive financial years, commencing from 2020-21. There has been disappearance of substantial liability of about 440 crores, which is the balance sheet of CD shows as short-term borrowing plus other liabilities. So 440 crores of liabilities have eroded on account of short-term loans and liabilities, short-term borrowings and liabilities. Also, failure of the RP to hold an audit, call it forensic if so, also considered appropriate. And to place these facts before COC appear worrisome. Also, the failure of RP to hold an audit, call it forensic audit or transaction audit, whatever, and to place these facts before the COC appeared worrisome. Adjudicating authority is not powerless to take note of unexplained depletion in the value of CD's assets, as it impacts the quality of information memorandum and hence the acceptability of the resolution plan. The commercial wisdom of COCs kept beyond judicial scrutiny is the one which is founded on intelligent decisions made on intelligible criteria, which manifests and reflects the IBC values as well as compliance of the procedures, but not otherwise. Given the fact that resolution plan born of a faulty resolution process cannot be sustained, necessarily the order directing liquidation requires to be upheld. So, while it is a fact that commercial wisdom of the COC is supreme, the adjudicating authority must see also if there has been a depletion in the value of assets and there is no corresponding explanation available thereto. The circumstances that CD is, the CIRP cost is being paid from the funds of the CD, including encashment of fixed deposit, which has been made just before the commencement of CIRP. There has been substantial appreciation in the value of the assets or net worth of the SRA. No transaction audit or forensic audit has been done. And while there are circumstances that we see that substantial reduction in liabilities, then liabilities means what? Liabilities on short-term borrowings and loans and advances, and correspondingly depletion of assets. So on this kind of circumstances, adjudicating authority felt that commercial wisdom maybe it is beyond judicial scrutiny, but it has to be an intelligent decision, which has to be made based on intelligible criteria, which manifests and reflects IBC's values as well as compliance of procedures, but not otherwise. And if such thing happens, adjudicating authority is not to close its eyes, it can order for liquidation, reject the plan and order for liquidation. So with this, we move on to the next slide. Viewers, we are on the screen of section 52, which deals with secured creditor in liquidation proceedings. And our topic of interest is topic number 14. Yes, 14, which says that more than 60% in value of secured creditors decide upon a course of action. Such decision becomes binding on the remaining creditors. We had earlier seen that pertaining to claim and things, there was a PHEL judgment which said that 60% of the creditors have to accept. But this is enforcement of the rights of secured financial creditors. So this is for the first time we are getting a definite answer that which says that more than 60% in value of secured creditors decide upon a course of action. Such decision becomes binding on the remaining creditors. The cases of STCI Finance Limited versus IMP Powers Limited, Fruits Liquidator and others, Company Appeal so and so of 2024 and 2025. In this case, what happened was STCI Finance, that is the financial creditor. It had given a loan of 39.5 crores or something, and it during liquidation process, it wanted to take over the assets and go beyond without getting into liquidation. It did not want to relinquish its security interest. It said that it will take over the assets and sell it. The liquidator consulted, and there were other lenders also. And so the liquidator took a legal opinion and denied such request of the secured financial creditor and proceeded with auctioning of the asset as if the rights have been relinquished. The security interest has been relinquished. The matter was challenged. And the matter went to NCLAT. This is a long judgment, quite very long judgment, I would rather say. And also deals with section 53, but essentially this is a section 52 judgment. So 53 is not so important because section 53 part was still under consideration of adjudicating authority. So here the NCLAT said that we are not getting into it because adjudicating authority is looking into the matter. So in order to make the case, this huge thing, huge judgment, summarize it, and put you in a tabular form, put you in a bullet form. So let me take you over to the slide which I prepared for you. Honorable NCLAT held that the appellant contended that it is a secured creditor holding a first pari passu charge over the fixed assets of the corporator pursuant to supplementary mortgage dated 4/8/2018. It had expressly elected not to relinquish its security interest while filing its claim on 17/1/2024 for an amount of approximately 39.55 crores. The corporator had availed multiple credit facilities from a consortium of lenders, including State Bank of India and other banks, prior to availing term loan of 25 crores from the appellant in 2017-18. The record shows that the NOC issued by consortium of lenders, particularly SBI, were conditional and reciprocal in nature, and such conditions were never fulfilled by the appellant. So when already there is a charge, if there is another first charge, and if somebody wants a pari passu, then obviously an NOC from other lenders is required, which was given by SBI and other consortium members, which were conditional and reciprocal in nature, and such conditions were never fulfilled by the appellant. The secured creditors holding 69.15% voting share had initially relinquished their security interest This figure went up to 85% when two more banks relinquished their security interest. That means 85% of the creditors had relinquished their security interest. When the appellant entered into term loan agreement dated 29/11/17, the assets of the corporate debtor were already charged in favor of existing consortium lenders, including State Bank of India. On 21 to 2024, the appellant objected and sought permission to realize its security interest under Section 52. However, significantly, no concrete steps for realization were taken by thereafter. What are the concrete steps? That it has to move to surfacing. It did not move. So no concrete steps were taken. STCI was to acknowledge the receipt, and SBI clearly stated that ceding of charge was on reciprocal basis, subject to similar letter by STCI, ceding pari passu charge in SBI's favor by STCI. Like when SBI had issued, they had mentioned that, like, I'm doing it, you do it for us as well. That is the meaning of pari passu. So which was never done. In the absence of a valid industry agreement, reciprocal ceding of first pari passu charge by STCI, the alleged pari passu charge never became operative in law. The liquidator in his email dated 21/2/2024 informed the appellant that in terms of Regulation 21A, he has to, within 90 days from the liquidation commencement, STCI needed to pay CIRP cost, workman dues, and liquidation cost. As a matter of fact, liquidation cost is supposed to be paid within 7 days of the liquidation order. But 21A2 definitely mentions that within 90 days, if it's relinquishing its charges, then within 90 days, the entire CIRP cost, workman dues, and liquidation cost has got to be paid. The failure to comply with Regulation 21A2 results in statutory consequence under Regulation 21A3, whereby the secured assets forms the part of liquidation estate. What happens if you don't comply with 21A? Then automatically it becomes a part of liquidation estate. In consortium lending structure involving joint security and involving disposal of fixed assets, Section 13(9) of SURFACE becomes applicable law under Section 52(4) of the Code. This is very, very important phrase. I'm reading it out once more. In a consortium lending structure involving joint security and involving disposal of fixed assets, Section 13(9) of SURFACE becomes applicable law under Section 52(4) of the Code. More than 60% in value of secured creditors decide upon a course of action, and such action becomes binding on the remaining creditors. So STCI, since they did not, 60%, more than 60% of the claim was with other creditors, its request for not relinquishing security interest was not acceptable, and liquidator was absolutely right. So this is, for the first time, such matters have come. It is known, this is a known matter, but this is for the first time in black and white, our judgment is there. So I would strongly request my viewers to please go through the judgment. With this, we move over to the next slide. We are on the dashboard of Section 95 of IBC, which deals with application by creditor to initiate insolvency resolution process against an individual or a partnership firm. But however, an individual and partnership firm presently is restricted to personal guarantors only. Our topic of interest is topic number 54, which says that registering one application before another cannot be allowed to be used as a ground by the respondent or personal guarantor to avoid the insolvency proceedings. The cases of Mohit Arora versus PNB Housing Finance Limited and another company appeals were so of 2020. This is a very recent judgment. Maybe of 29th or 28th or 29th April. So in this case, essentially what happened was PNB Housing Finance had filed a 95 petition, and after that, IFCI had also filed a petition. The petition filed by PNB Housing Finance was withdrawn with a liberty to file a petition afresh with additional documents, and the NCLT permitted it. The matter, IFCI and the guarantor, they moved to NCLAT. In between, PNB Housing Finance returned again with another petition, and a resolution professional was appointed therein also to submit a report under Section 99. And at the end of the day, the Section 95 was admitted. The matter went to NCLAT. NCLAT dealt with scrutinized the entire thing and came up with a wonderful judgment. So please go through the judgment, excerpts of the judgment, which you'll find on the website. But in order to make things short and precise, let me take you over to the slide which I've prepared for you. The date of filing of CPIB 20321 was 26/3/2021. On 8/7/21, the aforesaid CPIB 20321 was withdrawn by the respondent with the liberty to file it afresh. As I told you, PNB Housing Finance had initially filed it on 26/3/21. On 8/7/21, it withdrew the application with liberty to file it afresh. On 2/6/2021, now in this kind of situation, dates are very important. On 2/6/21, IFCI, the other creditor of the CT, to which appellant had stood guarantor, has filed a petition under Section 95 of the Code against the appellant. So 2/6 they filed, and this petition was withdrawn on 8/7/21. So before 8/7/21, this petition was filed. On 20/12/2023, Mr. Ritesh Kumar Agarwal was appointed as resolution professional. They are in to submit report in terms of Section 99 of the Code. PNB filed second petition, CPIB 395/2021, on 24/7/2021 against the appellant. Mohit Arora, appellant Mohit Arora under Section 95 of the Code, and this petition also, RP was appointed on 29/9/2021. So 2012, Ritesh Kumar Agarwal was appointed as a resolution professional, and PNB filed the petition on 2021, and against which on 2021, 29/9/2021, RP was also appointed. In IFCI petition number 428 of 21, the RP was appointed, and the appointment of RP was challenged by the appellant by filing an appeal before this appellate tribunal, and the said appeal was allowed on 5/4/2024. So who had challenged? Mohit Arora had challenged the corporate debtor, and the appeal was upheld. The order dated 2012-2023, whereby RP was appointed, was set aside on the ground that resolution professional has already been appointed by the tribunal by order dated 29/9/2021, passed by CPIB 395 of 21. Second petition filed by PNB. So because there was already an RP in action, On account of revised petition, the next petition filed by PNB, which was RP was appointed on 29/9/2021. So the RP who got appointed on 20/12/2023 was automatically set aside. The petition filed by, now we come to the critical part. The petition filed by IFCI, that is 428 of 2021 on 2/6/2021, was barred by interim moratorium commenced by filing of first PNB HFL, that is PNB Housing Finance Limited petition, being CPIB 203/21, and thus was honest in the eyes of law. This we have seen earlier also. Because once a petition under Section 95 is filed, other petitions cannot be filed because the interim moratorium begins immediately on filing of the petition. So the petition filed by IFCI was honest in the eye of law. The race between filing of two applications has resulted in this issue. And it is in the light of these facts and circumstances, it was opined by learned adjudicating authority that it amounts to misuse of the process of IBC. Registering one application before the another cannot be allowed to be used as a ground by a respondent or personal guarantor to avoid insolvency proceedings. So we know that Mohit Arora had earlier moved to NCLAT. He had moved a petition. So he was playing, the main point to create confusion because there were two petitions competing with each other, which was not intended to be, but it transpired to be because of the actions taken by the personal character, in confusing the court. The findings returned by adjudicating authority against the appellant is pertaining to abuse of the process and of material concealment of facts, which in our opinion is evident on record. There is no illegality in the impugned judgment of 11/10/2022 so far as admission of second petition filed by PNB HFL, that PNB Housing Finance Limited, 395 of 21 is concerned, and there appears to be no good grounds to interfere therein. We have seen cases like this earlier also, but therein the personal guarantor did not feature. But here, personal guarantor was playing a game between the courts and escaping the insolvency process, which was caught by the court. And they stopped this entire game and they said that this is not allowed. So by this is an exceptional judgment. So with this, we stop the screen share here and move on to our next presentation.
Viewers, we have come to the end of our presentation. I do hope you liked them, and the judgments were exceptional. You'll find them exceptional, and they imparted good knowledge to you. We'll see you again at the middle of May. Please give your likes and share our video with your friends and colleagues. As you know, guide2ibc.com is a free website, and the motto is to spread the knowledge of Insolvency Bankruptcy Code amongst others. And that we can only do through our audience, through our patrons. So thank you and bye for now. Thank you.